In regards of the definition of litigation, litigation means that a process of taking a legal action in court. Meanwhile, an out-of-court settlement is a form of alternative dispute resolution which is voluntary, informal and flexible. And then in regards of the issuance of notice of demand, in this point, whenever a solicitor receives a instruction from a client to make a claim, then the standard practice is to send the notice of demand to the defendant or the other client, to the other side party. And the purpose of such notice of demand is to inform and intimidate the recipient to comply with the demand or to negotiate a settlement. Okay, by then, for the course of action, first of all, as the solicitor for our respective client, we will discuss with our client about the proposal of the settlement by the defendant solicitor, and as we found it is reasonable to settle the settlement without involving the court, which may save the cost and time, then we will propose to our client to settle the dispute outside the court.
Okay, please halt for a second because I need to comment on the slides because I think it is too wordy. Banyak perkataan, okay, kurang image ya. So the point here is to try to make it more interactive using images and less words. Yeah. As I always I've reminded before that the trend nowadays is to go for infographics. So I would like to train my students to use infographic instead of the traditional PPT. Yeah. So kalau dalam case you sekarang ni, you are explaining the processes, yeah, the course of action that you would like to undertake, right? Yes, in consultation with your client. So this one is like a type of process which you can actually import some graphics to illustrate the step-by-step process that you will undertake, okay, in consultation with your clients. So tidak perlu tunjuk dalam bentuk perkataan tapi tunjuk dalam bentuk gambar. Dan sedikit sahaja description dekat gambar, tak perlu panjang, satu baris just to say what this process is about, and the rest is your oral explanation, yeah. So please bear in mind, takut nanti I will not give you good assessment lah kalau macam ni punya presentation, ya. Saya dah bagi tahu untuk students, please use more infographic. Right.
Alright, madam. Okay. Proceed to the another point. As we read in the Legal Profession Practice and Ethics Rules 1976, it is our duty as the solicitor to advise our client to prevent misunderstanding between the dispute party. However, if our client refuse to settle their dispute in settlement out of court, then we will proceed with the normal trial in the court. By then, the fact of the case for the Yap Cimeh and Ajinomoto Malaysia Berhad, on 22nd November 1971, plaintiff worked at defendant company suffered an accident while work which causing him blind. And then plaintiff instructed his solicitor to claim compensation from defendant, and then the solicitor filed a writ of summons against the defendant. However, before trial, both solicitor of defendant side and plaintiff side had gone for a negotiation for a settlement, and they had signed a notice of withdrawal of the earlier suit. However, the plaintiff said that he didn't agree to the negotiation, and then he appointed a new solicitor, which then he filed a new writ of summons against the defendant to claim the said damage suffered by him. However, nevertheless, the defendant then filed a writ to strike out the plaintiff's suit, as he alleged that the matter had been settled through the settlement by both of their solicitors. However, plaintiff rejected the application and mentioned that he had never consented of such out of court settlement. Okay, madam. Proceed to the judgment of the case. This case was in the High Court, and Harun J give his judgment. As a general rule, it is against the public policy to allow the settlement between solicitor on behalf of their client in the accident cases, which to be challenged with impunity, or in other words, impunity means the exemption from the punishment from the court. However, a settlement is like a contract, and it is voidable on the grounds of misrepresentation, influence, fraud, or mistake, which then the court can interfere to bring justice. However, in this current case, there was a valid settlement between the advocate and solicitor for both of the plaintiff and defendant, and the plaintiff also had failed to bring proof to prove the allegation, in which we found that in the fact of the case, the plaintiff himself has already signed the receipt of he getting the money from the settlement. Okay. Proceed to the other case.
Okay, Assalamualaikum warahmatullahi wabarakatuh. My name is Shatra Binti Zairani, 1160569. Okay, next, I will explain the case which contradict with the case of Ajinomoto, which in this case, the settlement can be set aside as there is found mistake or misapprehension on the part of the solicitor when giving his consent to the settlement. So this case is about Chiu Kongka and Chiu Kuan Cheng. In this case, the plaintiff had claimed for declaration that he and the defendant are partners in equal shares in the ownership of a cinema hall, and order that the partnership to be dissolved and the affair to be won out by the court for the appointment of a receiver and a manager and the taking of accounts and damage. However, the defendant alleged that the plaintiff had only 1/3 share in the partnership. The case had been settled in chamber with the presence of both counsel, but without the presence of the client. Before the consent order was drawn up and perfected, the plaintiff notified of the settlement, immediately notified the registrar and counsel for the defendant to set aside the settlement, as his counsel had given consent under a misapprehension. Noriani, judgment. Okay, as for the judgment for this case, the court allowed to set aside the settlement as the consent order had not been drawn up and perfected in this case, as there was existence of misapprehension on the part of the counsel. Next, for the principle of this case, where in the Lord Denning Indiat and Denning Chemicals Limited stated that a consent order is drawn up, it appears that the consent was given under a misapprehension or from a misstatement, then the party can come to the court and ask that the settlement could not be drawn up. For the next case, which is Neil and Gordon Lennox, stated that a counsel has no authority to refer an action against the wishes of his client or upon terms different from those which his client has authorized. If he does so, the reference may be set aside, although the limit by the client on his counsel's authority is not made known to the other side when the reference is agreed upon.
Can you explain in your own words what is the difference between this current case and the case of Ajinomoto in terms of the principles?
Okay, for the case of Ajinomoto, as we can see, the plaintiff itself failed to give evidence to support his claim that there was clearly a misrepresentation on the behalf of the counsel. For the case of Chiu Kongka, as this case, the plaintiff had found evidence and tendered to the court as there was existence of misapprehension on the part of the council. So the settlement the settlement can be set aside.
Okay, can you go back to the slides on the judgment in the case of Ajinomoto? Okay, the plaintiff in this case failed to prove the allegation of fraud, misrepresentation or undue influence. Okay, was the negotiation conducted with the clear consent of the plaintiff?
Madam, as we found in the fact of the case, the plaintiff said that he had not consented to the negotiation or the settlement. However, his act of receiving the money from the settlement and sign the receipt had initially proved that he had already consented to that settlement himself.
Okay. So there was no grave injustice caused by the solicitor, and there were acts or conducts that amounted to ratification of the of the settlement or compromise. Am I right? However, in the second case, okay, can you go back to the last slide maybe? In this case, was the undue influence element or fraud or misrepresentation proven?
For this case,
yes.
Based from the facts, it was only stated that the plaintiff notified to the registrar as the settlement there was existence of misapprehension on the part of the council only, madam.
Okay, can you go back to the slide on the facts again? I would want to recall what kind of misapprehension was that. The plaintiff only have one third share of the partnership. The case had been settled in chamber with the presence of both counsel, but without the presence of the client. Before the consent order was drawn up, the plaintiff notified. I don't understand the last sentence. Before the consent order was drawn up, the plaintiff notified of the settlement. What do you mean by the plaintiff? The client or the solicitor?
The client.
The client was notified or the client notified? It makes a big difference now. If your grammar is not in order, what I get from this sentence is the plaintiff maybe was notified of the settlement or he notified somebody else about the settlement. Which one is which? So he actually was notified of the settlement and then he went up to the registrar to apply for the settlement to be set aside. Am I right?
Yes, madam.
Sebab tak clear ni, you punya ayat ni boleh, it can be misinterpreted. So make sure somebody, you have a like a check. You kena check. Let someone scan through your slides, okay, whatever you want to present, so that we get a clear idea, okay, and explanation is not interrupted by sentences like this, ya. So kena be careful dalam submission nanti untuk yang saya cakap the assignments that are still left to be done. Please make sure you do not have issues with sentences that can be misunderstood, yeah. So make sure you proofread your work and ensure the quality is not compromised. Sebab 70% tu banyak ya datang daripada coursework. Okay, third and the quiz. So for the quizzes, make sure read the materials that I have uploaded, and also for the legal talks we've had before with 2 speakers, make sure you understand the content, and I might like create questions out of the talks by the speakers as well, right? So what conclusion can you make, okay, and how does the conclusion tie back to the question here? Okay, can you tie the conclusion from your presentation to the question? What did the question ask just now? What are the steps, right? So what is your conclusion from this presentation?
As for the conclusion, we can conclude that it is the duty of the solicitor itself to advise our client and act accordingly with the client's needs.
Okay, but make sure bear in mind there is like a difference in terms of the approaches in the case of I think litigation, criminal, right? So make sure you understand what amounts to an ordinary course of conduct, okay, which does not actually require the lawyer to get an express permission from the lawyer for every transaction or maybe a compromise. So but it is always best to go back to your client and get his proper consent and approval, ya. Ada soalan ke berkenaan dengan presentation before we move on? Kalau ada lagi. This one is TLB 1 ya?
Madam.
Okay, TLB 2 ada nak present tak? Ada question from maybe other topics such as privileges ke?
Yes, madam.
Yeah, please.
Question 1 from topic 4.
Question 1, topic 4, ya?
Yes. Wafi, could you please help me to share the slide? Okay, thank you, Wafi. Shall I start, madam?
Yes.
Okay, Bismillahirrahmanirrahim. Assalamualaikum and very good morning. Not yet 12. Okay, good morning to everyone. So I'm Abdul Had from TLB 2, sorry, matric number 1160570. So my task is to present the tutorial question 1, topic 4. So second slide, please. Okay, so the question is, A client says to B, an advocate, I have committed theft and I wish you to defend me. I want you to inform the court that C is the person who has committed the theft. However, the advocate refused to represent A and inform the police about the said communication. Analyze the above situation. So basically, this is a problematic question. So let's see what is the issue for this case. For this question, sorry. So there are 2 main issues in this case. First, whether B, the advocate, is permissible to refuse to represent A as an advocate. Means, is it permissible for B to refuse to represent A, as stated in the question? And the second, whether it is permissible for B, the advocate, to disclose the communication made by A to him as it is relating to the criminal purposes. As mentioned in the question, B would like to inform the police about the said communication. So these are these are two issues relating to the question. So let's move on to the next slide. Okay, thank you. So generally, in Article 5, Clause 3 of Federal Constitution, when a person is arrested, he shall be informed as soon as may be of the grounds of his arrest and shall be allowed to consult and defended by a legal practitioner of his choice. So the gist of this article is when a person is being arrested, he has the right to consult and defended or represented by any legal practitioner on his own choice. Okay. Second, the legal professional from Legal Professional Practice and Etiquette Rules 1978 in Rule 2, an advocate and solicitor shall give advice on or accept any brief in the courts in which he profess to practice at the proper professional fees. So in this second principle from LPPER, it is stated that advocate must give advice and accept any cases or any brief from the client, and he may charge a suitable or a suitable fees from his client. Next. Okay, and then in section 126 clause 1 of Evidence Act 1950, this is privileges, which is a communication made between a client and advocates is confidential. Okay, confidential unless permitted by client to disclose. So there are three communication which shall be confidential. First, communication made by him as advocate to his client. Second, the content or condition of any document for purpose of professional employment. And third one, any advices given by him to his client. So basically in this section, it states the privileges of a client or the right of client the duty of advocate to not disclose any of these three communication to other third party. And also in the case of Minter, Popper and Prius, the right to have such communication so protected is the right of the client only. In this sense, it is the privilege of the client. So in this general rule, this is a protected right of the client to not being disclosed any communication made between him and his advocates and solicitor. However, there are exceptions towards this right or these general principles. Next slide, please. Thank you, Afi. Okay. In section 126, clause 1, paragraph A and B, this exception stated that advocates may disclose any communication made for illegal purposes. And second, any fact observed by advocate showing that the crime had been committed. So if there is any two of this situation, the advocate may disclose or may inform this kind of communication to the third party. And also there are illustration stated, illustration A relating to the when a client says to an advocate that he had committed forgery and wish to the counsel or wish the advocate to defend him. From this illustration, it is known that as the defense of a man known to be guilty is not a criminal purpose, this communication is protected from disclosure. So basically, this illustration explains the first or paragraph A relating to communication made for illegal purposes. So if the client confessed to the advocate that he had committed a crime, so it is not a criminal purpose or illegal purpose of action. So it is such communication will be protected. However, in illustration B, if the client wish to obtain possession of property by the use of a forgery on which I request you to sue. So in this kind of communication is made in furtherance of a criminal purpose, and such kind of communication is not protected. So it means that advocates may disclose this kind of communication when it's necessary. So to apply this kind of general principle and the exception towards the issues. So as for the first issue, B must not refuse to represent A despite of the confession made by A, as it is the right of the client to be represented and defended by legal practitioner, as mentioned in Article 5 Clause 3 of the Federal Constitution, or Federal Article 5 Clause 3, stating the right to be represented and defended. And second, despite of any crime committed by A, i.e. the client, B still obligated to advise and represent A in the court of litigation with proper fee. So as referred to Legal Professional Practice and Etiquette Rules 1978 Rule 2, advocates may charge a proper fee or suitable fee and must and obligated to represent his client. However, in issue number 2, so in the first issue, B must not refuse to represent A. That's the conclusion. So in issue number 2, whether it is permissible to disclose such communication between A and B. In the issue number 2, confession made by A that he had committed theft is protected from disclosure. A defense of a man known to be guilty is not a criminal purpose. Referring back to section 126 of in illustration A, A had committed a theft to B, and such communication is not listed under exceptions in section 126(1). Therefore, the advocate cannot disclose such confession. However, the second part is when A or the client asks the advocate to inform the court that C commit the theft. He tried to blame other people, and such communication was made in furtherance of criminal purpose, which means he tried to blame other people. He tried to charge other people, not charge. Yeah, he tried to blame other people for the criminal that he had made. This fall under exception in section 126, clause 1, paragraph A. This communication can be reported to police and can be disclosed. Okay, so as for the conclusion, the last slide, advocates and solicitors shall not deny rights of client to be represented by any legal practitioner. And second, communication made by client which intended to be confidential must not be disclosed. And third, only if consented by client, then communication between them can be revealed. Any communication of criminal purposes shall be disclosed as the exception is provided by statute. So that's all from my presentation. So is there any question? Thank you.
Okay, thank you, Abdul Haq. Do you have any questions? Or may I ask a question from your group members? TLB2, right?
Yes, TLB2.
Can I call upon Adib Hanisa? Can you quote any rules from LPPER, okay, which are relevant to address the question presented by your colleague just now?
What is stupid?
Do you have any provisions in Legal Profession Practice and Etiquette Rules 1978 that you should refer to in answering the question just now? Ada Adibah tak kat sini? Adib Hanifah. Adib Hanisa ada? Dengar tak soalan saya? What about Nur Afnida?
Madam, can I
Yeah,
try to answer?
yeah.
Under Rule 2 of the Legal Profession Practice and Etiquette Rules 1978, the rules said that he may refuse a particular brief provided that he is able to justify his refusal in the special circumstances.
He may
This
refuse.
a particular brief, maksudnya a case. If the lawyer able to justify his refusal in that case.
Okay, we are more concerned with the the privileges of the client, and also to what extent must he ensure that his conduct does not breach the privilege, okay? Or if there's no privilege, then on what ground? Kenapa you tak perlu protect the information? Do you have anything from LPPE? Not about accepting or rejecting a brief. This is about something that you must not do in this for the sake of protecting a certain information that pursues a criminal intent, for instance. Ada tak? I think the previous group did actually quote two provisions from LPPE. Cuba you go through. Do you have your LPPE with you? Cuba tengok. Okay. Did you come across anything in the rules to justify that you must not protect that kind of information? The second information was actually about the prospective client asking you as the solicitor to, engage in a plot to accuse another person of committing the crime that, he confessed to have committed. What about Rule 17? You must not practice any deception on the court. Okay. Any other provision?
Madam,
Yes.
Section 15 of LPPER. Rule 15, I'm sorry.
Rule
So Rule 15 of LPPER states that solicitor full attitude court.
Respectful attitude ni cerita lain. Kalau deception tu may be relevant. Respect tu if you to maintain your respect lah. Okay, towards the court. Okay, saya rasa ada satu lagi provision. Sekejap ya. The upstrust and litigation. Even client from conduct. Okay. Kalau bukan dalam ni, it is perhaps from the LPA itself, other than the Evidence Act just now. I think there are like very relevant provisions which you can refer to. I think you can maybe consult TLB 6. Last week they have present on this question, and I think it's relevant for you to also refer to the provisions. Saya tak dapat cari. I think I wrote it somewhere. Nanti tengok balik ya. Okay, so in all, there are like quite the statement made by the client is quite tricky. Okay, the first part is his confession. The second part is his asking you to try to collude with him. Okay, getting another person to to allege that he has been involved. So try to fake up facts, or maybe evidence. So that one is in pursuant to a criminal intent, which is not protected. Okay, other than 1 to 6, right? You have to also, you may want to refer to 1 to 9. Can somebody display what 1 to 9 is about if you have the real provision from the Evidence Act, maybe? You have 1 to 9. Abdul Had, can you display 1 to 9 other than 1 to 6?
Sorry, madam. I'm using phone right now, so I'm asking Wafi to help me to display the slide.
Other section 1 to 9 from the Evidence Act. How is it different from 1 to 6?
Madam, as I recall, section 129 talks about litigation privilege, right?
Boleh display tak?
Boleh. I open the Evidence Act first. Okay, here.
Okay, 1 to 9. No one shall be compelled to disclose any confidential communication taken place between him and his legal professional advisor unless he offers himself as a witness. Okay. In which case he may be compelled to disclose any such communication necessary to give and explain evidence. Okay. Note that this is in communication involving the client and his legal professional advisor. Okay, so the context, can you scroll down to 1 to 6? Scroll up. Okay. 1 to 6 doesn't mention legal professional advice, but communication in the course and for the purpose of his employment as advocate, alright, or to state the content of condition of any document ataupun oral communication in the course of other purpose. So the facts in the question fall within 1 to 6, right? 1 to 6. So you have to identify whether it falls within the exception A or exception B. Just now, what was your conclusion? Is it exception A or B?
My conclusion is under A, furtherance of any illegal purposes.
Okay, pergi balik ke Evidence Act tadi. Okay, B is about any fact observed in the course of employment showing that crime or fraud has been committed. Okay, so B is something that has been committed. A is in furtherance of an illegal purpose. Okay, so it fits A, and illustration is very relevant, especially when it comes to Evidence Act. illustrations are there to assist you on how you would want, how you should use the, okay, that provision. The contextual contextual application is assisted by the illustrations given under the provisions. Ya, kalau provision ada illustration, please use them. Alright. I have committed forgery and I wish you to defend me. Alright, this is protected. Okay. A defense of a man to be guilty is not a criminal purpose, but asking you to actually do a crime, another attempt to do a crime may not be protected. But yalah, ada questions posed whether you should go to the extent of reporting that person to the police. I don't think that it goes to that extent, okay, unless you think that he has the right, very 100% commitment to really do the act that he intended you to do with him. Ada evidence menunjukkan he will act further, he will he will do things that are against the law. Ada clear evidence, then you should do what is necessary. Otherwise, you should advise lah, okay, that it is wrong for another person to be accused of the wrongdoing. Okay, so 1 to 6 and 1 to 9 ada dia punya penggunaan tersendiri. Okay, I hope you can. Ada satu artikel by Screen. Have you heard of law firm by the name of Screen? SKRINNE, I think, Screen.
Yes, madam.
Okay, there is an article written on privileges, touching on 1 to 6 and 1 to 9.
Yes.
Please go and read through the article for you to further appreciate, because that article actually refers to the latest development in Malaysia. Okay, what is meant by legal professional advice? Is it also covering advice given by, for example, a company secretary? Company secretary is a lawyer attached to a corporate body or corporation. Okay, macam lawyer untuk company, dia in-house lawyers. Would that communication made by such in-house lawyers be covered under 1 to 9 as well? Okay, so benda-benda macam ni kena tengok cases. Okay, dia ada maybe different application, whether it is covered or not, you have to find out. Okay, dan please refer to TLB berapa tadi, TLB 6 lah. Saya rasa dia ada quote relevant provisions in the LPA. Okay, saya tak jumpa pula. Rasa saya record dari LPA. Mungkin di bahagian disciplinary proceedings ni, section 92 onwards. No, sekejap. Disqualification. The misconduct is which section, if you can recall? So kalau you tengok ya, 94 ni, 94.3C, dishonest or fraudulent conduct in the discharge of his duties, okay, amount to misconduct ya. Dishonest, okay, dishonesty and fraudulent conduct. Okay, ada soalan lagi tak before kita end the session?
Madam, I have a question.
Yeah.
Okay, soalan saya. Kan ada exception A tu kan, kita kena proofkan dia ada nak buat illegal illegal things lah, macam illegal purpose kan.
Yeah.
Lepas tu dia punya burden of proving tu nanti jadi on balance of probability jugalah kan?
What do you mean? If the case goes to court ke?
Kalau dia nak cakap saya invoke, contohnya lawyer dia bagi tahulah communication dia, lepas tu dia kata ada illegal purpose. So nanti dia nak proof yang benda tu akan dibuat untuk illegal purpose tu bergantung kepada balance of probabilities jugalah.
Let's say lah, if he actually if he reveals the part that he believes is not protected, like the one made in furtherance of any illegal purpose, and it is later challenged by the prospective client. Is that what you mean? And challenge, and the thing,
Yes.
the matter goes to the court.
Yes, madam.
I'm not sure on the burden of proof, but of course the lawyer has to submit proof and evidence that the client actually communicated and did take steps or actions in furtherance of the illegal purpose. What illegal purpose? And he has to convince the court of that lah, because it is a defense for him, right? Yeah, but on the burden of proof, I'm not so sure. Yeah.
Okay, thank you, madam.
Apa lagi soalan untuk 126, 129? Privilege is owned by the client. If he decides to actually waive it, sometimes he waive it expressly, but sometimes impliedly, betul tak? Ada case that I shared with you in the lesson before, involving this company, where I think the content of some documents and advice were revealed in an affidavit. Okay, and then it was later decided that the parties had no intention to actually protect the communication as confidential. So mungkin secara tidak langsung, but okay, by way of conduct, okay, boleh. Alright. So biasa kalau dalam praktis kita letak confident we actually mark our document as okay, without prejudice ataupun PNC lah, okay. That is the best the best step to take, okay, to show that the communication, whether especially written form, is meant to be confidential. All right. And as for communication, as a lawyer, you need to be aware of what is the client's privilege, to what extent it can be exposed or divulged to third parties or to other parties, including to the court, right? So tak ada apa, saya rasa setakat tu. Please read the article that I mentioned. Boleh Google screen SKRINE privilege, type privilege, ya. Itu saja. Alright, so sebelum you sign out, I would like to download the attendance. Sekejap ya. So show participants, kita ada, nampak 5 plus 22 in the meeting. Okay, 22. Okay, boleh saya tahu ni seorang student yang selalu problematik, nama, siapa nama dia, Muhammad Zarif ni. dia sebenarnya wujud ke tak wujud, apa status dia, siapa boleh bagi tahu, because nanti exam tak boleh ambil final semua. Memang kalau ambil pun fail sebab coursework 70, exam nanti 30 saja. Apa status student ni, siapa tahu, boleh bagi tahu saya. Dia tak pernah join ke dia ada join? Saya tak check betul lagi, saya just download je attendance tu. Can you hear me?
Yes. Madam, dia pernah join juga lecture ethics.
Oh, pernah join. Berapa kali? Tapi kebanyakan tak ada kan?
Yang tu saya tak pastilah, tapi pernah nampak. Ke saya salah lecture?
Kalau ada email dia, tolong share dengan saya, bagi WhatsApp ya.
Okay, sure madam.
Tu hantar surat amaran lah. Okay, so harap yang lain tak ada masalah attendance ya. Kalau ada, bagi tahu saya melalui surat berapa kali you tak hadir, kenapa. Okay, takut-takut nanti bila saya chat tak cukup lah. Okay, problem nanti. Okay, so dalam Julai nanti insyaAllah kita buat quiz ya. Quiz tu kalau you tak ada isu, saya nak buat live macam ni, everybody has to log in and then I will download the attendance. I will try to do it through Google Form, but you do it within the time frame that I shall provide, but it is live macam kita buat aktiviti sekarang. You dah buat quiz tak before this?
Maksud madam quiz tu macam mana?
Before
Quiz
this
lah.
ada quiz.
Ada soalan kena jawab.
Before
Quiz
this buat dekat goals madam.
Tools.
Goals.
Tools tu ada quiz kan. Saya ingat nak guna tools tu lah, tapi saya nak buat macam live. That means I am monitoring it online. Macam you hadir macam biasa, tapi masa tu kita buat quiz. Masa soalan tamat, maka tamatlah quiz tu. Dia boleh set kan masa dalam tu.
Madam,
Ya.
So far tak ada lagi subjek yang buat
Quiz online.
live. Live online quiz.
Ada masalah ke? Saya cuba nak buat.
Just nak bagi tahu, belum ada lagi lah. We
Saya
never experience that thing.
Sebab macam kalau kita buat offline ni, boleh juga set time frame pada masa yang sama. Tapi macam nak cuba buat online sebab nampak student tak ada masalah untuk ni kan. Tak ada masalah coverage sangat. Ada ke student kita yang terpaksa duduk kat kampus sekarang sebab nak guna internet?
Kalau kampus tak sure, tapi ada yang perlu balik ke nilai lah. Setakat ni ada beberapa student yang stay di nilai untuk dapatkan internet coverage.
Student saya ada.
Imran?
Student saya ada tak? Balik nilai.
Ada madam. Saya lepas tu
awak.
budak TLB 5.
Okey,
Ada
Muhammad
budak
Imran
TLB
ke?
6.
Muhammad Imran
Ya saya.
Awak duduk kat mana?
Ya, saya sekarang kat nilai.
Dekat asrama lah.
Dekat rumah sewa.
Okey. Kalau duduk kat kampung memang tak dapat
Ya. Banyak distraction dan yang tu pun internet tu memang problem. Wifi tu problem.
Wifi problem. Sekarang you all guna internet apa boleh saya tahu tak? Telefon ke?
Mobile data.
Kalau saya
Mobile
pakai data lah sendiri.
Saya nak tahu kalau data dekat area Kelantan, Terengganu apa yang okey?
Yang tu saya tak tahu lah madam, Terengganu
Sebab saya nak beli ni untuk saya nak balik kampung nanti. Saya nak buat kerja kat sana. Kalau you tahu you mobile okey, beritahulah. Tempat saya tak ada line tu. So saya pun nak cari yang okey.
Satu lagi madam,
Yeah.
My housemate,
Yeah.
student TLB 5, dia rumah dia dekat Perak. Kalau balik kampung dia memang takkan ada line.
Nama apa?
Fadil. Muhammad
Sekarang kat
Fadil
mana?
Fauzi.
Sekarang kat mana dia?
Perak. Fadil kat mana?
Dia join tak?
Tapi kelas dia join sebab sekarang ni dia dengan saya dekat nilai juga.
Okay, tak apa. InsyaAllah nilai tak masalah. Cuma macam universiti support tak benda-benda mobile data ni?
Ada madam, tapi yang tu dia macam selected sikit lah. Dia bagi USIM bagi RM38 sebulan macam tu untuk for 3 months only.
Oh, you tak apply ke yang balik nilai tadi?
Dia bukan based on application, dia selected kepada B40 macam tu lah. Tapi still ada yang tercicir jugalah.
Kalau you perlukan any bantuan because of that, universiti tak boleh support, you let me know. Mobile data ke apa-apa. Okay, you let me know so that the lesson are not interrupted. Kita pun boleh tolong student, tak masalah. Just make sure that you let me know je apa keperluan yang apa tu untuk you continue with the rest of the lesson ya. Okay, itu saja. Tak ada apa-apa.
Madam.
Ya.
Sebelum kita tamatkan sesi hari ni, saya nak tanya pasal assessment. Takut ada nak ulang balik, takut ada salah. So 30% untuk markah peperiksaan akhir final. 70% adalah berdasarkan 4 assessment, iaitu case review, infografik, dengan quiz, lagi satu video presentation. Okay.
Pembahagian markah tu masih di semak fakulti. Benda ni ambil masa lah.
Oh, I see. So maknanya ini adalah macam belum final lagi lah.
InsyaAllah dah hampir final. Cuma allocation mark untuk 4 tu saya tak boleh nak cakap sekarang.
Oh, I see. Allocation mark
Sebelum ni mungkin saya akan ambil sebagai tutorial punya ni. Kalau betul-betul 4 tu bila dia dah email dekat saya, okay. Betul-betul 4 tu saja dan allocation of mark dia akan beritahu lah.
Lepas tu yang soalan saya tentang assignment semalam tu, madam kata on hold tu maksudnya macam mana? Tak decide lagi dia dikira sebagai assessment ataupun soalan tutur
Dia mungkin bawa soalan tutur. Kalau dia nak saya ambil artikel or case review, maksudnya yang tu saya tak boleh kira.
I see.
So kita akan bincang tu sebagai tutorial. Faham tak?
Faham. Tapi
buat sekarang ni.
Tapi belum final say lagi lah kan?
Tengah disemak oleh ketua timbalan dekan kalau tak silap.
Okay, terima kasih madam.
Okay. Alright. Ada masalah lagi So that's all for today. I will meet Firza 4 to 5 kan? The next tutorial yang kita arrange for today.
Untuk tutorial 3 and 4.
3 and 4, okay. Alright, okay. Thank you So I will end the session. So